Justice isn't about fixing the past, it's about changing the past future. With this little thought knowledge, I wish you all a very good morning, a very good morning, and welcome you to day 2 of the induction program of the School. With this, I invite our you today, Advocate Mrunalini Deshmukh, to write the inaugural lamp. Shri Gandaya Gajamukha Mureshwara Siddhida Ballarastu Vinayakasta Bhavati Chintamani Sevare Leelādram Girijātmajam Sumaranam Vighneswaraschodhare Grāmīrāṅsalam Samskrito Parambhakti Kuryāt sada
for the second day of the induction program, Advocate Mrunalini Deshmukh, staff and students of BMI School of Law, staff and students of Nari Goswami Law College, who are observing this program online. A very good morning to all of you. I hope you have studied and you remember one of the greatest warrior emperor of ancient India, Ashoka the Great. Anyone here who doesn't know him, has not read him, studied? Ashoka the Great, son of Bidusara, Kalinga War, change of hearts, against spread of Buddhism. Now you must be wondering, why am I talking about history and Ashoka the Great? Give me a second and you will understand. He was the most powerful and the most renowned monarch of that period. And H.G. Wells, a reputed, prolific English writer, in his outlines of history, has compared Ashoka to a shining star, a solitary star, in a sky studded with millions of stars. He writes like this: amidst the tens of thousands of names of monarchs, the name of Ashoka I repeat, I'm quoting H.G. Wells. He says, amidst the tens of thousands of names of monarchs, the name of Ashoka shines and shines almost alone as a star. Now, if I had to use that simile for our chief guest, I would read like this. Of the tens of thousands of names of the family code practitioners, the name of Mrunalini Deshmukh shines and shines almost alone like a star. With these words, I extend a very warm welcome to our chief guest, of all assembled here and those who are watching this program online. Not only is Mrunalini Deshmukh an outstanding lawyer, but she has another facet to her personality. And that is, she is a very popular teacher. When I was at the University of Bombay teaching the LLM students, we had to specially invite her because of her knowledge and expertise to join the university as a visiting teacher. And I recall, I think it was 2 days a week, maybe 2 days a week, we had her at the university out of the 6 days. The amazing thing was, those 2 days when ma'am was in the university, the students used to flock and throng at the gates of the university to hear her. It is really unfortunate that we have lost such a popular teacher to an outstanding lawyer. But there is one more thing which I would like to share with you, and perhaps that is the best one which has touched my heart. When we were planning this program, of course, we wanted to invite her. But the question was, $1 million question, will she accept our invitation and be able to spare her time? Because for every second is precious and very expensive, because she has dealt with cases of Hrithik Roshan, okay, Amir Khan, Adnan Sami, Karishma Kapoor, and maybe many more, you know. So whether she will be able to spare the time, I decided, let me try. I sent her a WhatsApp message. That answer replied, it will be a pleasure to be with you all. We will fix the day and the time next week. True to her promise, Advocate Mrunalini is with us this morning, and that too gratis. So, once again, I welcome an outstanding lawyer, a popular teacher who was very well received by her students, and above all, a very humble and a generous Mrunalini Deshmukh. Thank you.
Now request Professor Rishi Han to introduce our speaker of the day, who will enlighten us on family law.
Unmute करने का है बस.
Thank you, ma'am. Good morning, everyone. I graduated in economics from Xavier College, Bombay, and I'm intern for LLM. Advocate Mrunalini Deshmukh, part of the teaching area at AC Law College, Bombay. Ma'am is a renowned lawyer with professional experience in the field of family law for over 2 decades. Ma'am belongs to a family of jurists wherein her father gained a certificate of a constitutional expert and former vice chancellor of the university. Ma'am has presided as judge for various local competitions. Ma'am also addressed and contributed in writing towards issues of sexual harassment at workplace and the safety of women and children. And has been invited as an expert by several agencies or committees on the same issues. And strongly believes in gender justice and has addressed domestic and international conferences on issues relating to family law and the structuring of wealth and equity issues. Ma'am has recently addressed an international conference on wealth planning for global Indian families in Dubai. Ma'am has authored a book on divorce, taking up to a step-by-step guide getting divorce, published by Penguin Publications. Here is the book and it's available in our time. Ma'am has also dealt with cross-border cases and has been invited to give legal opinions in foreign courts such as Oxford Court, New York Court, Dhaka Court, Florida, and Dubai, and has also been examined as expert witness. Ma'am has to predict several conferences and events where she has addressed national and international audience such as Columbia University students and South Asian Canadian Conference on sexual and domestic violence in South Asia, and the international lawyers and jurists from countries like USA, UK, Australia, and other South Asian countries on the ethics and values of legal practice. Now I request Advocate Mrunalini Deshmukh to address the gathering.
Good morning. This is really a bright sunny morning. Outside the atmosphere is a little dull and gray. To see such bright faces, the brightest of all you who have invited me to be a part of this morning. I'm truly honored and privileged to be part of this morning's, I would not call a lecture, but a discussion or interaction that I'm going to have with the young students. Now, before I get into it, I must say that my relationship with Mr. Mrunalini is that of a soul sister. And that is because she was my father's student who did her research under my dad. And my dad would always tell me, if you have to have some lady role model in your life, how to study, how to be so immaculate in your work. On the top of those subject, with research, with case laws, with all the material available, you have to learn it from them. And this is what the words of my great honor, which are resounding in my ears even now, and more so when she called me. How could I ever say no to her? No way I could have done that. So I'm quite grateful that she invited me here, and I'm also happy to share what I proposed, what I have done. I think both Nilima and the lady here have been too liberal and they have been too generous and overflowing with a lot of things. Not all of that is true. Yes, my only thing here is that I have been doing family law for the past 2 decades, if I can put it. Prior to that, as Nilima had already, Mr. Nilima has already told you, that I was a visiting professor at the University of Glasgow. And I had the opportunity of teaching the same subject, which I could now later practice as well. This is the background, and I now want to sort of, get into it. Please remember, this is not a boring lecture. I'm not going to teach you law. I'm not going to teach you and take you through all this part. It is just a conversation, a dialogue that we are going to have. And a little edge I have over you because I've been practicing with law. Probably that may help you to get a little bit of guidance. But when we were discussing what subject I should address the students on, and she put it for me to decide, I thought the best way to start this was, what is the scope and the future of family law? Should it be an option that students are going to now enter the legal profession after the completion of your studies? Should they take it up? Is there scope? What does it involve? What kind of character does a lawyer need to have to deal with these kind of cases? Because please understand, these are emotionally high-strung cases. There are people who are in crossfire, who are emotionally in a very turbulent state of mind. having felt a sense of having lost everything in life. And at that point of time, when they come to a lawyer, what should be the role of the lawyer? So it's not going to be strictly about what they teach you in the law books, and they say what they teach you at the Harvard, but it is going to be much more and beyond the course and beyond the realm of the four corners of the statute that, of course, at the end of the day, we have to do. So in fact, before starting this, I would just like to give a small quote, which was by Abraham Lincoln. And I think that applies very, very much to the kind of practice that we do. He has said that as a peacemaker, and please mark it, as a peacemaker, a lawyer has a superior opportunity. I mean, if you read, so listen to it, it sounds a little contradictory. A lawyer is a litigant, he or she is going to fight and then be a shark, as the popular saying goes, or whatever the case may be. But Abraham Lincoln felt that as a peacemaker, the lawyer, and I think this is very important when you study, practice, and take up family law as your profession. The reason for saying this is, and I'll tell you, family law is what, at the end of the day, we dealing with family matters. But there is a special enactment, like most of you may be knowing, that in 1984, the Family Courts Act came into existence. And that enactment is the one which is now dealing with all the family-related matters. Prior to that, we had, it deals with cases like Section 7 of the Act deals with the jurisdiction, it deals with cases like divorce, it deals with cases like judicial separation, restitution of conjugal rights, child custody matters, alimony, maintenance, and separation of property, stridhan, and other issues which are. So it is a very wide gamut. And when we are studying the family law, these are the concerns which are there. A little background is prior to the Act, did we not have divorces? Did we not have separation? It was there in the uncodified laws. Later on, when the statute came into existence, they got translated and had a better format and a structure to it, which came. For example, I was taking as a matter of example, and then the reason for it, that under the uncodified legal law, there was concept of separation, there was a concept of maintenance for the widow, there was a concept of child care, custody is the term which is come later. And in 1955, the Act came into existence when the Hindu Code was codified. And that is how now we have a structure taken. So what are the various enactments that we come under? So Indian laws, Indian marriage laws, personal laws, in fact, all personal laws, not only marriage, are still based on religion. Because we are a country of a diversity. And we do want to keep our identities when we are there. And that is what the law has protected. And that is what the law has understood. That this is the ethos of the Indian society, and the Indian law has to be in tandem and not at crossfire. That is why you have the Hindu Marriage Act. For the Hindus, you have the Muslim marriages because that for the Muslims. Then you also have the Parsis, Christians, etc. And you also have a secular act, which is the Special Marriage Act of 1950, where two people from two different religions, without giving up their religion or converting or taking some other religion of the spouse, can get legally married and still retain their identity, and which is known in popular parlance as the civil marriage or court marriage, as we call it. So this is the backdrop of what we are also sort of, we are going to be working around. Now, why is it that we need what is a valid Hindu marriage? A valid Hindu marriage is when two Hindus at the time of marriage, they get married, perform certain ceremonies which are mentioned in the Act. So you have to understand that the Act incorporated some of the traits and some of, I would say, the essentials, what is there about the Hindu religion in the enactment, like there is a section 7 which talks about the essential ceremonies of marriage. So you do have to have those essential ceremonies. But at the same time, it is also a contract. So Hindu Marriage Act is both a sacrament and a contract. Why sacrament? Because you have these religious ceremonies, and why contract? Because you have an age of marriage. The girl has to be 18, the gentleman has to be 21, because that is when you understand the concept and you get enter into a contract. So this is a blend that we have, and so on and so forth in the other. So interestingly, we sometimes get cases, and I think I should share this with you. And I think I have done at least, I don't know the exact number, but several cases. People are in love and they want to get married. So there is a Hindu who wants to get married from us. Nothing wrong. They don't want to do any research, they don't go to lawyer, they don't do any research. Because and nowadays, of course, everybody wants to have a big fat wedding with 10 ceremonies and 20 clothes. All the girls will know that, buy all the lehengas and get ready, and everybody. So nowadays, I sometimes wonder whether people understand what marriage is, or they don't understand what the celebrations are, and not really what it is. But that's all I'm thinking. So people get married. So a Hindu comes and he falls in love with the Parsi and he gets married. He goes through he or she, both of them go through the Vedas. They also register their marriage under the Hindu marriage. Okay? So it's not so that they go now, it's confirmed thing. We've done the Vedas. It's registered by the registrar of the marriages. Things are okay. If they live together, nobody will question. The problem comes when they have to do. Now, how do they get divorced, and under what act do they get divorced? They were married under the Hindu Marriage Act. That's not a valid marriage, because maybe one of the spouses is not a Hindu. Okay, neither did he or she convert into Hinduism. So that is not a valid marriage. But what happens if it's a valid marriage? Then how do you, under what law would you? And I struggled. Let me be very honest to you. Initially, when this case was came, even I didn't know how to go about it. Under what law do we go? If I go under the Hindu Marriage Act, it's going to be a technical objection, because one of the parties is not a Hindu. So how is the act applicable? Because you see section 1, section 2, it says it is applicable to Hindu. Hindus include, Buddhists, Jains, etc., etc. So, but this is a completely different religion. So then we came out, and when I say we came out with the court. So the law gets handled and interpreted and given a better, or would I say, a better explanation would be judgment, rather than the bare acts or the words which are. So we went under the specific, and under the specific relief act is regarding the declaration of the legal character of the marriage. So when under specific relief act, if you read the section before, it would say that when one of the persons say A and the other person is opposing regarding etc. issue, including the legal character, which is in this case the relationship, then the courts will decide. But here there are people who voluntarily want to go mutual consent divorce. They don't want to fight. They have made up their mind, okay, we were in love, we got married, but now we want to divorce. We want to do by mutual consent. We don't want to make any allegations against each other. He didn't cheat me, I didn't cheat on him. Even at the time of marriage, both of us knew, except that both of us were not wise enough to take an opinion whether this is the correct way of going. But barring that, there's nothing. However, then the law has developed, and then we go under this section and ask for the annulment of the marriage, as if the marriage never existed at all. But so far, so good. That's fine. What happens if there are children born from such marriages? Because it doesn't mean that the couple has to come for a divorce before the child is born. No. They can also come for a divorce after the children are born. So the children are given the legal status of children born from this marriage, which otherwise children born from void marriages are not termed to be. I hate to use the word legitimate children, because children are always legitimate. The relationships are either legitimate or otherwise. But so these are the kind of issues that come up. And when they come up, we have to think outside the box and think what is the way for the courts to grant the relief that the parties are asking. That's one part. Now, I'm sure, I don't know whether you have the act for your family law, and I'm sure most of you must be aware. But I will take a couple of minutes to explain to you what a procedure happens. Now, when a matter is there. Suppose a petition is filed. So there are two kinds of divorces on the law. And I'm just talking about divorce first. I'll come to the rest of the issues. If a couple wants to divorce, they want to do it voluntarily. They go to a lawyer, draw their terms and conditions, and they decide no allegations against each other, incompatibility, breakdown of marriage, you need 1 year of separation, 1 year from the date of marriage, all those things which are there in section 13, capital B of the Hindu Marriage Act. And just taking Hindu Marriage Act as an example, there are equivalent and parallel provisions in the other acts also. So then they go, what is the procedure? You go to the court, you file the petition. Once you file the petition, then the courts at some point of time give you a time where you are supposed to go to the court, to the judge. Then the judge will verify for you, you husband, you wife, what are the documents, what is the proof of marriage. Because tomorrow you can ask anybody, and I'm going to tell a very interesting story also. Not story, it's a reality case, not in Maharashtra, but in. So, and then they have to identify each other. And they say, are you sure you want to go for the divorce? They say, yes. Do you want to rethink, reconsider? They say, no, we have made up our mind. Then he verifies that he or she, the judge verifies, and sends them to the council. The council is attached to the court. And the council also takes the basic things and finds out whether there is any pressure, coercion, undue influence on any of the spouses to go through. Because that is the role of the court as per the statute, that you have to go to ascertain all that. Assuming everything is ascertained and the courts are okay, then he gives a report that I tried to reconcile them. Because the endeavor of every judge, every lawyer, every counselor, every person from the fraternity should be first to ensure that the parties to reconcile. If there are minor differences, restrictions which are there, whether we could overtime them with counseling, any kind of external help which is required, and so on and so forth. And then the matter goes after 6 months, so the active 6 months from the date of marriage. Sorry, from the 6 months from the date of the presentation of the petition, and maximum to a period of 18 months. That's about. Then after 6 months, also the courts again verify and ask them, listen, you had a cooling off period of 6 months. Have you guys thought about it? Do you want to do it? Do you want to reconcile? Do you want to reconsider? Do you need some more time? So it is done with a lot of options given to the parties concerned. And then this is the easiest, and I would say if the parties are determined, then a graceful way of exiting from the relationship without throwing market to each other and without getting into it. That's it. Now, after having said this, the issue that arises over here, what happens in a contestant? A wants a divorce and B doesn't. Or both want a divorce, but they are unable to agree on the terms and conditions. It could be that situation also. Or both of them want a divorce, but they are unable to come to who will have the custody of the children. One child, 2 children, whatever the case may be. Or both want divorce, but how are we going to have separation of the marital assets and separation of the property that we have got? So there could be various issues. Or in some other cases, the other spouse may say, I just don't want to divorce. For various reasons. This is where the conflict comes up, and this is where the issues sort of take a different role than what we saw in the earlier one of the mutual consent petition. And then they have to go to the lawyer, they have to ask what is the way out. Now, this is where I want to share something with you, and I think it's extremely important for you to understand. And the book that this lady referred to, I have said that the first thing that a family lawyer, I would like to call as just categorized as a family lawyer or any lawyer dealing with a family, has to first don the robe of counsel. He or she is sitting in that chair, and there is a person who is in front of you, is completely in a fragile state of mind, completely broken, not knowing what way to do, where to go, what to do. Under such circumstances, that is the role of a good lawyer is A, calm him or her. Give a direction, this is not the end of it. It's betterize the problem. Or we could make the existing things each other. Once he or she has calmed down, then discuss with them. B, possibilities, if at all any, of reconciling with any of these things, especially that when kids, because we feel that when we have brought the kids on this earth, should we not make an extra effort? If you're single, independent, there are no kids, probably life is a little easy. But when kids are concerned, we do need to get it done. At that point of time, we do have to first tell them to think about it. And if divorce is inevitable, then to do it in a graceful, dignified manner, considering what the expectations are. But even if this doesn't happen, then the third step is you have to file a case against the spouse and write down everything that has happened, which is the ugliest part, which I'm actually amazing. It's really, really sort of, as they say, exposing the other, the person with whom you have probably shared a bed, gone on holiday, shared a meal, you had family, festivals to get into one. I get that. We also have in the family courts, at least I'm talking about where I'm sure they have something, what is known as a pre-litigation counseling. So if a couple wants to go in for a divorce and they want to do it, the courts have the infrastructure to provide for a pre-litigation. They don't get into litigation. That is what's sorted out. So there are mediators who are trained mediator who get into a pre-litigation. Even when these contested matters get into the court and they are hotly contested, at every stage effort is being made to bring about the solution, whether by the judge who is deciding the matter. We also have what is known as court-trained mediator. So there's a panel which is there. And if the courts feel that these things can be resolved, then they are referred to the mediator. The discussion between a client or a litigant and a mediator is a privileged communication. The mediator is not supposed to disclose that to the court or give any opinion on that. He or she has to just try and see if he or she can resolve the issue. And a mediator's report is a two-line report. Mediation is successful, parties are willing to live together on these terms and conditions. Mediation failed, then mediation successful, parties want to divorce on these conditions. Or mediation failed, and parties cannot come to any understanding. So these are the three things, that is all. The mediator cannot say that the husband was unreasonable, the wife was unreasonable, she was very greedy, he was very stingy. None of these things have been told. And this is the idea behind this. This is what I want to explain to you. The idea behind this is to give an opportunity for the litigant to just flow before an independent person to be able to see if there is any possibility of any solution. But not that it's for example, when you go to a psychiatrist or a counselor, okay, and these are going to a counselor, there's nothing wrong about it. It's like you have a fever, you have headache, you go to a doctor, and you have some mental issue. The communication between the litigant and a counselor, litigant and say a psychoanalyst, litigant and a therapist, psychiatrist, etc. Again, the privilege of communication, which the specialist does not share with the other. Because you cannot use this communication and use it in a court of law and these certificates are given. The only time that he or she can do is if the court summons the psychiatrist or summons the psychologist who is there concerned. Say that I need to understand what it is. I need to actually get on the matter. Only then they can come in a court of law as an expert witness and make it. Otherwise, this information cannot. So at every stage, the reason I give you these details is at every stage, effort is being made to appreciate the dignity, the grace of the relationship. Try and do it in as far as possible graceful manner without stepping on anybody's toe and getting it done. I always say, like they say, and give a surgeon. Who is a good surgeon? A good surgeon is one who knows when not to open. Not who knows when to open. But a good surgeon is one who knows when not to open. Who is a good family court lawyer is one who knows when not to go for a divorce or advise particular litigant or litigants if they are coupled to go for a divorce. And that is the role I feel that you should. I'll give you an example. In fact, in the book also I teach it. That's because this is something, not example, this is something what I have seen in my professional life. So there was a young couple who came to me. So they must be in their late 20s or maybe early 30s. Very bright, sort of thing. They came, now when you come to a divorce, I mean, like, ask, okay, guys, when did you get married? And since when you said, I'm married. Then I said, oh, this is for somebody from friend, cousin, etc. On which he said, no, it's about us. I said, what about you? So we are planning to get married. So I said, I've come to a wrong place because I'm a lawyer. She said, no, we have come exactly to the right place. But we they said, ma'am, with your experience, etc. We would like to know what are the mistakes that couples make in their marriages when they come to you. And what are the wrongs that they do? We need to know that prior to it. If we go to a counselor, the counselor will tell us that you should be understanding, you should be accommodated, you should, etc. Which is also the correct way of doing it. But we thought that we wanted to take an advice from someone like you with your kind of experience. How and what are the problems? What are the red herrings? What are the warning bells? What are the things that we should see before? And if you tell us that we see that, we want to correct it. Because we do want to have a long-lasting marriage and we want to be together till we grow old. But we thought we should take advice. I think it was something which was an eye-opener for me also when they came, because I really never expected them to come. And then I think they were to their friends or things like that. And quite a few of them started to understand. I think it's a very progressive and very practical approach taken by couples who are very educated, young, and things like that, to be able to understand what are the pitfalls, what are the warning signs, what are the. I think this is all. That's what happening. The other thing that I would like 5 minutes more. Oh, sure, please. Okay, no, I don't want to take much of your time, and I mean, I want you to ask me more questions rather than me just going on monologue. So I'll just take another 5 minutes and I'll see. So in family laws, we have different kinds. And since you're a student of law, I'm going to understand it more than you can part of it. So you have the Muslim law, which still has the Sharia law, which is still the uncodified. So for example, a woman, if she wants to take divorce, she has to go under her personal law, which is the Kula, which is where she gives up all her claim. Or she has to go by the Mubaraka, which is a mutual consent as we call it. These are the only two options available. But let us appreciate one thing, and this is pre-independence. This is when the British were ruling, they realized that the Muslim women, and I'm talking about this particularly because hijab hearing is now going on in Supreme Court as we are speaking here, that they came with a solution to help the Muslim women to have an enactment to be able to take divorce, which is the Dissolution of Muslim Marriage Women's Act of 1932. Please understand that Act is of 1932, pre-independent. So if she did not get a divorce by Kula from her, what they have, the Jamata or whatever, or she did not get by mutual consent, the court gave her the option of bringing out the grounds of divorce. There may be cruelty, there may be alcohol, there may be which entitles her to get a legal divorce from this. Also, the other concept, as you might have done that, you have seen the Shaira Khan's case about Julie Talaq, the brilliant reasoning of the judiciary and giving so much of relief to that. And I have done at least 10 of such cases. And I can just tell you the latest one which came to me. There's this lady who came to me, she must be around 22, not a young girl, 22, 23. And she came with her father and she was crying, sobbing. This man is working as a tailor in one of the designers. So very simple, very basic, very modest, not much. The girl was 22, but at that point of time, she had done her 10th standard or 12th standard. And she got married. And So apparently there was some issue. And while she had come to her father's house to visit, there was this piece of paper which is crumpled like this and thrown at her. He came, he threw it in the house, and then he went away. And then whatever was written on that, he just took a photo and sent her on a WhatsApp. He said, "You were divorced. I've not divorced." This girl was completely heartbroken. She was tortured by my lord. Things like that. This is when this Shaira Bag's case of triple instant talaq, which was there. And I have seen what the woman goes through when this is there. Her just word comes to an end, it collapses. But having said this, today what is the recourse for the men? Can they not ask for divorce? Now that triple talaq has been declared as a non-constitutional, not right in law. No. Unless they don't have an enactment for the Muslim men, they still have to go through their Sharia law, which is the uncodified law. But now the process is, we have said this one. Ask the wife whether she needs to be supported, taken care of, their children, what is to be done. She has to respond. If she doesn't respond, notice 2, which is after a month, and notice 3, and then at the conclusion of it, some kind of mediation or an arbitration is done, and she's free. So the option for talaq is still there for the Muslim men, but what will be taken away from them by the judgment is the instant triple talaq, which was used absolutely arbitrarily and, sorry to say, on the advice of some sort of, how do I put it, without no respect. Some of these mullahs are just want to make a big buck and, without caring for impact on the family, on the wife, and so on. So these are the different nuances of the law which is there. And for example, you will appreciate that the Parsi Marriage and Divorce Act, it still is in the High Court. It's not decided in the family court. Why? Because they have a jury system. So how you have in America or Amber Heard and all these things that you heard about the jury system, even to decide a contested divorce, they have a jury system. And my experience in that court has been, it's a very, very exasperating thing for the judge also, because there's a couple who's fighting, their lawyers are representing them fighting, and then there's one jury which is so much fighting between themselves that the judge doesn't know who should I take care of. Should I take care of this tickets or the clients who are in front of it? Should I ask the jury that, listen, if you can't come to a conclusion, it's all right. We'll go by the rule of majority, or if you don't have to do that. So anyway, this on the lighter side. So I've seen many a time just in front of the I mean, what can you do? What can you do? Y'all decide, I'll wait, I'll wait. Y'all tell me what is to be done. So this jury system is still there, which, I mean, there are many suggestions given that it should be done, etc. I have come to this entire scope. Is there scope? I just think another two. I think you have to you can take it because I want to show you. I think so only whether there is scope, and I'll give you my example, and I think that is important, not because it's about me, it's about them. So I was earlier, as she knows, I was teaching. Then I got my son, and I started working for a year or two. And I was working then at HMG. And we were doing a lot of interesting written matters and so on and so forth. Then I conceived, and then I was asked not to work because maybe pressure, pregnancy, etc. So I have a son who today is 32 and my daughter who is 35. So I took a break for 15, complete break, except that I was teaching. Because my father would say that the only way to be in touch with the subject is when you teach. But when you have to speak for 1 hour before the student, you have to prepare yourself for 2 hours. And for that, you have to study for 3 hours. So, he said that's the only way you will get it. That's what they wanted to mention when I was a teacher and I was doing a part-time. Obviously, because my kids were one, I could keep them for a couple of hours, not 8 or 10. When they started, they were in school, and when they started coming, we leave at 8:30, come at 9:30. I thought I should now start doing lawyers. The lawyer in me was always there. The teacher was there, but I wanted to do. And when we started staying in Bangalore, that's when the factory got home. So I said, commuting to High Court, coming back to take me 2 hours. Can I start something here? When I'm back home, the initially nobody gets involved. Nobody's going to look at you also as a lawyer. But you can just come back in 5 minutes and you're back home for the children so that whatever that goes, things are going to be like. So that is how I started with my. And I mentioned that in a lot of my interviews. My first client was a toddler's daughter. And I did the entire matter for her in 1.5 years. It went on with the trial at the in the Royal Princely Summer Trial. And it's, why do I remember that? William had mentioned it about her. I don't remember. I remember this because I tell you why. And it's a very emotional thing for me. Her father used to come, the girl's father used to come, and he didn't know anything. They were Marathi, simple people from some town, they didn't know anything, whatever I would say, they would sign, they would do everything. She got a divorce, she got whatever reasonable amount at that point of time. They paid me 500, which was a thing for me. And then in a paper, that's something that father gave. So I didn't know what it was. So I opened it. There were golab chocolates. And I was so overwhelmed and I said, what is this? He said in Marathi that I'm waiting for you. I said, my side, saying, no. When we were talking to her and doing, I was watching your feet. And that's the time I got it. I went and it fitted like a glove, believe you. That man, I've never given any of the measurements or etc. Well, these are the moments, these are the things that I hold in my heart. And this is what really makes me feel that if I have done something, it's for that girl where I started my career. And for this Muslim girl who was a victim of triple talaq and so on and so forth, that gives me the real satisfaction. So, students, there is a lot of scope. There are high-stake matters, which Nima said that I have done. There is a lot of, today, unfortunately, but I tell you, when I started my career around 18, 19 years back to the family law, the number of cases in the family court were around 300 to 400 in a year. Okay, that was some of them had been transferred from the city civil court. Today, the numbers are 15, 20,000. And much more. This I'm just giving you a very conservative number. So is there scope for this field of law? Yes. Is there a demand for it? Yes, there is. Is there a demand for good lawyers? Absolutely. Always believe your ethics and values will only make you a lawyer along with your studies and your research. Because unless you have a combination of all that, you do not want to be known as someone. And these are issues and these are cases where people want to use all these things for you because they want to have a quick gratification. So your values, your integrity, your ethics on one hand, and your hard work and your experience, there is no looking back. Guys, those who want to take family law, you have a great career ahead. Always remember that being a consensual lawyer, beside the hard work and intelligence, is extremely important in this kind of law. And I'm sure you always do this same as those of you who take that. So there is scope, there is a way of going about it, and surely there is something that you can give. Comfort and see, joy is too strong a word, but a sense of relief that the warring couple has is immeasurable. And that cannot be, so I would like to call it joy, but a sense of relief because they are out of tumultuous territory. Thank you so much for all your patience. And giving me this opportunity to share with you my thing. I didn't want it to be very technical. I have promised Mr. Nirvani that if she feels appropriate and I'm fit enough, I would like to come and lecture on the subject that we are on academic and only from that point of view. But this is more to give you a panoramic view of what could the family law be, what does it entail, and what does it mean for you to be a family lawyer. What are all the things? Thank you so much for giving me this opportunity. Now I know your questions. What would say here? That's it. Yeah, whatever. I mean, do you have a question that I can?
Should I give my? Okay. That's fine.
No, you want the mic? It's okay. Oh, you have the mic.
Okay, what is starting with? I hope you have a lot of questions.
That was really so enriching. Thank you so much for your time. Just a question, since you mentioned that, as you rightly mentioned that a lot of the times when a couple goes through divorce, they're obviously not in the best state of mind. And there's a lot of trauma, sometimes you need counseling and therapy. So just have a question in relation to that. Is it possible to recontest a divorce settlement that you may have signed? Because maybe at that point you were not in the best state of mind, or you didn't have support from like parents or a lawyer or something like this. So what's the scope once you sign the divorce to go back? That might be complicated.
No, it's not complicated. It's a very relevant question and you should understand. And that's why when I started, I said a very two kinds of divorce. One is a consent divorce and one is a contested one. Now, in a mutual consent divorce, once you all have agreed for it and the courts have passed the order, there is the act itself does not give you a scope to reopen that unless there are any extraneous circumstances. For example, I'll just give you a very simple example. It may not be for the divorce. When you signed the petition and it was decreed, the custody was with one person. Okay, so it was with the mother. You are a father, you are a guardian. The child has grown up and the child has become 12 or 13, and he now wants to have the custody because the father feels that he can provide better future, education, etc., etc. Is he bound by what he is agreed on, or is there an option in law where he can approach the courts and ask the courts to reopen only that limited issue of the custody? Now, as far as your consent for divorce is concerned, there has been a lot of case laws and a couple of well-known case laws. I've been part of that proceeding because they were my clients. So the law that, and then again I'm taking Hindu Marriage Act because that was the law under that. Section 13B of the Hindu Marriage Act says that the consent to the divorce at the time of the filing and at the time of the pronouncing of the order has to be free without any commercial undue influence, etc. However, the mutual consent petition allows you the option to withdraw your consent after you have filed. For example, you filed in January of 2022. In March, you realize, no, I made a mistake, and that is why the cooling off period is given. So the cooling off period is given for parties either to reconcile, or if they don't want to reconcile, if somebody doesn't want to give a divorce, or somebody feels pressurized or cheated, or whatever the case may be. So when you go after 6 months or 18 months, which is the maximum period, that is the reason why the court asks you again, are you sure we've given you enough time? If 6 months is not enough, come again after 2 months. We are sitting here, we can give you even your divorce after 8 months. So at every stage, at every step, the courts are going to take into consideration whether the wishes and the desire and the willingness of the party is free, frank, without any activity. Vis-a-vis a contested petition, where you have suppose the husband files for divorce and the divorce is granted, the wife is unhappy. She has the process completely going to the high. She has an option of going to the Supreme Court and appealing against whatever she feels has been unfair on her or whatever has been otherwise she needs to challenge. So in a contested divorce, you have these steps of going to the high, from the family court to the high court, when you put to the file, and then by women to the Supreme Court, where at the highest court we will decide what is to be done. And but as far as the mutual consent is concerned, there could be cases where you are, that is why given the option of withdrawing your consent prior to that. But there could be extremely sort of very few cases where there has been these cases, but the courts may consider reopening. But sometimes what happens is the other spouse already got married. Then even if you reopen the case or the courts reopen it, it becomes infractuous. Because he or she has got married because he got a divorce by consent. And consent divorce cannot be appealed, it cannot be, gone into the higher court. So I got a divorce today, I can marry tomorrow. That's what the law says, because the mutual consent. You have a waiting period, only if there is in a contested matter. 90 days is a waiting period. You can't get married because the option is given to the other spouse against you. You have to go into the high court and appeal and get whatever relief she wants. But in a mutual consent, you can marry the next day. So what is the purpose the courts are going to serve in this matter? And the taking man and single argument has already got married. Then that entire exercise become infructuous. And then maybe only what some negotiations about settlements can take place. But you miss the bus if one that right. Thank you.
So as rightly mentioned by you, that personal laws have basis from the religion. And in India, where especially in matters of divorce, where spouses live with wrong. And then still, these couples are then classified as per their religion. The emotions are classified as per their religion. And so I strongly believe that the answer to this is a uniform civil code. So what's your views on that? And also, how can it be implemented and what are the challenges that can persist by
I think it's a very, very nice issue that I brought up, and I'm happy that I will have the opportunity of expressing myself on this. Absolutely, I think it's high time we get over this religious thing, which I'm not saying compromise with your religion. Please follow your religion, you please follow their religion. But religion is a private space. And that is what has to be respected by everyone. Whether I'm a Hindu, Muslim, Parsi, etc., it's a matter. But if there is a uniform criminal proceeding like the IPC, which does not look at the religion, which does not look at times gender, but does not look at any of these factors, why can we be uniform? I'm all for it. The propaganda which is being done against it are twofold. Because I've done a lot of study on that. I addressed in Gujarat, in the Baroda conference, which was on whether it's happened about 8 years back. Now it's come up again because of the government, but I'm not on the political part of it. I'm only on the academic and the part of it. And I had addressed a gathering, and I had said that the concept of the opponents of uniform civil code feel that it is impinging on my religion, asking me to not follow my rituals, asking me not to do certain things, and that is why they want to bring about some code. But the uniform civil code is nothing better than a Hindu code, that is what they are doing. I disagree with them. Because the uniform civil law only means only laws of divorce, succession, child custody, inheritance, etc., will be decided by one common law, where religion will not take place, it will only take place on the facts and circumstances of that particular day. Nobody is asking you, nobody is telling me don't go to the temple and pray. The Uniform Civil Code is not saying that. Nobody is telling you don't go and do namaz 5 times a day. Nobody is telling someone don't go to the fire temple or don't follow Ramadan or don't do Ramadan. That's your private space which you can do it. You should have uniformity of both the laws. They also the opponents, and since I'm for it, I want to tell you what they are going to say. That they are trying to marginalize the women, which is not true. It is not true that the Uniform Civil Code is trying to marginalize the women from the minority community by this. In fact, it is going to give an extra empower the women with the same rights. Today, the Hindu women are blessed to be having so many laws which are empowering them against the, if I say that, as compared to the Muslim women who are there. Today they have to fight at every stage, all economy, they have to fight for instant triple talaq, they have to fight for everything. If you have a uniform civil code, they will be at par. And it is something which is, in a true sense, brings about gender justice. irrespective of what your religion is. Religion is not what they are going to do. They are going to bring about equality, Article 14, Article 15, Article 21, right to life. Everything is covered under these things. So uniform civil code, I strongly believe should be there, that if there will not be these contradictions which take place, there will not be any issues, and there will not be any kind of sort of, shock changing the women, more particularly in all these issues which are there. Today, you see the Hindu Succession Act. I'll just give you an example. How empowered that act has become. A woman born in a family becomes a co-partner, she inherits all the rights of the ancestral property. Just see the laws as far as succession are concerned in the other sort of communities, especially the Muslim communities. Why are you, because of whatever, and again, this is not about Hindu Muslim that I'm getting into it. I'm just saying uniform civil code is a must only to empower the women of all communities, of all castes and of all religions, because they have to be on an equal platform if the country has to grow. Of course, the men are in that, but more particularly from the women's point of view.
Two questions. One is from the perspective of the family law, and one is from the perspective of the law person. From the perspective of the family law, we have been taught, we have a subject called Book also. We have a session wherein we are specifically being taught about how to go against your obvious bias when you read a case. Okay, so then these family problems are very emotional, as you rightly said at the beginning. And they are definitely going to inflict a kind of bias in the lawyer's mind. So how do a family lawyer generally overcomes a bias like this, which is more so in family law cases? This is first part of the question.
I don't understand. What is the bias you looking?
For example, there is a divorce case,
Right.
and you strongly feel they shouldn't be divorcing.
I probably.
Yeah, as a lawyer, you feel
Okay.
so you will try to counsel that.
How do I go? Yeah, got it. I got it.
So it's an obvious bias. This obvious bias will overcome. Other than criminal cases, you family cases, you have more divorce.
Second,
Second is question about the law itself. Everybody feels, or most of the law fraternity feels that uniform civil code must be there. At the beginning of when the constitution was made, it was put as a directive principles of state policy, because that time they were not. Today we feel that we are still not ready. But according to will be the likely time or likely number of years, under the given state of affairs, the Supreme Court is giving judgments like Induction and still taking the shelter of Article 142. Would the civil code is no, uniform civil code is likely to come in?
I think I'll answer your first question. It's a very sort of pertinent question that you asked. What happens if a client comes to me and I feel from my whatever wisdom, experience, etc., that this is not a case for the divorce and they can win. So this is my assessment of this person who is before me. And I'm giving my advice in a very honest, candid manner, what I feel. But at the end of the day, I'm a lawyer. And I have to go on the instructions of the client. If the client says that, ma'am, you're absolutely right, I respect where you're coming from, and I don't want to go against what your advice is, but I truly believe that I will get my relief, my freedom, only if I am divorced. Then of course I have to do that. That's my duty, that's my mountain duty. But what I'm saying is that when I was addressing you, the issue that I was trying to make is that as family lawyers who deal in family law, your first objective should be to see if reconciliation is possible. That genuine effort you have to make. You're not a counselor, you're not a shrink, you're not a psychologist, but you have the experience of family law, you know what happens. You know, see sometimes about the trauma of the children that come from the broken, because you've experienced all that as a lawyer. So in good faith, with genuine bona fide intentions, you tell the person, but ultimately his desire, his wish, after hearing that is important and you have to act on that. But then you work for him with a very clean conscience that you have given him the correct advice what you feel is correct. But you have to do it because lawyers act on instructions of the client. The second part of it, which is the continuation of the uniform civil code that we just discussed. So there are two views about the Uniform Civil Code, that when the Constituent Assembly was debating and what should form parliamentary advice and what should form directive principle. This thing did come up for a Uniform Civil Code. But the history, and this is what I just vaguely remember what my dad used to tell me. At that point of time, the Hindu code was also codified at that point. At no point of time the Constitution wanted to give any kind of sort of, an impression that there is the codification which is happening on the Hindu code is something which is reflecting on the Uniform Civil Code. So they had to tread very, very cautiously, because India is multicultural, multi-religious, diversity is there. And they didn't want to step on anything. Though the members of the Constituent Assembly felt that this would be better for the country. But they said, yeah, we just framing the Constitution. There could be errors, we all make errors, there could be errors, there could be such a thing that we maybe do them in oversight there. Let's not keep it because we feel it should be there. Let's keep it as a directive principle so that in future there is something, a provision in the Constitution itself, which talks about the Uniform Civil Code. Let's not be very aggressive and make it as a part of a fundamental thing or a constitutional provision. To answer your question, I think what they did in their own wisdom was absolutely fine, because India was early 47, 50, and then 50 the Constitution came. Everything was so new, and they were also trying to sort of understand what is really required. And today we are so happy and proud that we have the most robust constitution in the world, which is so dynamic with the different nuances it has. How much time will it take? Probably I have no idea. But the way I look at it, just as a common citizen watching things which are there on the media and otherwise, I think this government is very keen to make it into an enactment. And if they are successful to do that, probably we'll have it very soon. And I believe as a lawyer, I believe as a lady, I believe as a person, it would be beneficial. And these are my views. No political inclinations in this. Just a pure, simple citizen and a legal citizen person. That's what
Hello, ma'am. My name is Jimmy. I wanted to ask, how do you get into the clients? A lawyer also plays the role of a counselor, right? Because in a family law, the client is, first of all, he's trying to get into, or he's against his family members, his whole members. So, how do you get into, how do you get into them?
I'm not thinking about the question. So are you trying to say that if a person wants and his family is not supporting him, how do I convince the family or something like that? I'm not understanding.
How do you treat them? Because first we need to be a counselor. Is it compulsory for a lawyer to be a counselor for their clients?
No, I would not say compulsory. I'm just sharing my experience. So please don't take it that it is a part of the enactment or a part of the procedure. I have over a period of time in the last 18 years, in my own wisdom, in my own experience, that we as family lawyers, especially after some 5-7 years in practice, having seen 5 cases, should be able to tell the client the futility of the litigation, the futility of family breaking up, the aftermath of it on the children, if there are something which you should be able to give them a candid view about it. It is not at all mandatory, or it is not at all compulsory as far as this is concerned. I can just tell you one thing, and I think I'm slightly answering your question, but not completely. Initially, when I started my practice, and I'm talking about the girls who want to get out of marriages, young girls, maybe 5 years in marriage, with child, without a child, etc. The constant thing, and every parent is always there, and just change that. It's okay. If your mother-in-law is not treating you well, it's all right. She'll understand your value. Or if whatever the issues of your husband is unreasonable or he's being insensitive, take every passage of time, etc. And the parents would be there. So I remember in my early years of practice, if a girl came to me and girls were comfortable with lady lawyer, they came to me, they would come with a cousin or a friend or someone. Because nobody at home there. So they would be at a cousin of theirs or a friend. Say, They'll say, my father doesn't know about it, my mom doesn't know about it. Obviously, my girls don't know. But we want to find out what can I do. I'm very unhappy with situation. Segue now when we come. Today, the parents come with the girls and say, I don't want my daughter to be sort of languishing in this kind of a situation. Please help her out. Please tell her what I'm not like. Then please get her out of it. Because I care for my daughter. Not that those parents didn't care for their daughter, but there were these social things which were there. How come the girl can leave the house and come back and do a parent's house? So we have graduated from there to understand that what is important in this is not the social customs or what the neighbors say or the family, but what is good for my child. And this is where the parents have now realized that they say we have come to you. Only because if my child is really trapped into some kind of relationship which is very toxic, very, very toxic for her, we do need you to help us to get out of it. So this is a change that I have seen from persons, especially women, men was different from say 15 years back or 18 years back to what today is. And I think, I'm not saying it's a positive change because it's what it was. It's a positive change because acceptance by the parents and not getting in those age-old things. What will somebody say, neighbors are doing it, and what will the society say? They now don't care. They now care only for what the child is. And they say do whatever they do. So this is, in a way, a gratifying thing which helps the girl to really express herself to her parents and so she say why she needs to get out. It's very comforting to the girl that my parents are standing by and I'm taking such a major decision. So this is the change that I see.
So Hindu Marriage Act is a sacred. After a uniform civil code, will the Hindu marriage would be considered still as sacrament, or it would become a contract like other religions?
So, my understanding, and again, I'm subject to correction because I'm not really sure what could be a uniform because there's no draft, skeleton or things like that. I think what the act will like to say that if I'm a Hindu, I can get married as per the Hindu rites, right? There's no question about it. I can go around the holy fire, I can do something with the marriage, etc. If I'm a Muslim, between the contract and marriage, I don't want to do. So you may be permitted in my reading, again, as I said, I have no idea. You may be permitted to follow your personal way as far as the marriages are concerned. Okay? But there could be something like a compulsory registration of everything. Today, though there is a section, for example, even the Hindu marriage section, you say that the marriages have to be registered. Not all marriages get registered. I'm not talking about Bombay and Delhi and all. I'm talking about, say a tier 2, tier 3 kind of thing. Unless you make a registration of a marriage as the only valid proof of a marriage. And then irrespective of what your religion or community is, you will be governed by the uniform civil code. That is one way of doing it. So it does not entail taking away from me my religious ceremonies which are required. I need a pandit, I need a mother, I need the fera, and all I should have it. That's what my right to religion is. Article 25 is also saying the same thing. Your religion, your religious practices will not be taken away. So that's what I'm trying to say. I answer this gentleman. That the concept that the people who are against uniform civil code are trying to spread is that they are trying to trample on your religion and take away all whatever your religious rituals and rights are there. No, that's not the way. It is only when you have to decide at a particular point, whether it is about divorce, it is about custody, whether it is about alimony, there will be one uniform law applicable irrespective of whether you are Hindu, Parsi, Christian, or inheritance. You have one single law irrespective of what you are. Today we have lopsided, as I said, the Succession Act is a very robust one that empowers the Hindu women. While the other religions like Muslim, we see are not so robust in giving inheritance rights to their daughters or whatever things are there. So that discrimination which is there, which is existing, and again I'm saying I'm not talking about any religion. I'm just talking about whatever the discrepancies are there. Polygamy will be obviously banned because if you give the monogamy, the rule of the law, which is there in the Hindu law, obviously every polygamy, which is a blessing for the women. So the uniform civil code is more to empower the women and bring for gender justice is what I feel, and not to take away your religious beliefs and rights and rituals. Yes.
As a family, what is your take on marriage?
It might be very vocal and everywhere you find it on the net also. I have got quite a loss from that. But yes, so my simple, I do not get any legality to pre-marriage reason. If rape is a violence of women, whether it is in the marriage or outside the marriage, the rape is a rape. A rape is violence. And if rape is to be criminalized outside, why should it not be done within? Okay, and I will also subscribe to the opposite view is what, and to speak for the men because it should be a fair comment. They feel that some women may misuse it. But as a lawyer, and law students, and you're going to be the budding lawyer, does a misuse of a law means you don't have a law? No, right? You can put checks and balances. You can keep, make it very stringent. At the same time, I must say, and I didn't have time, and I didn't want to really take much of your time. In that today, there are a lot of laws which are empowering women, and I'm catering to the basic section of the crowd over here. There are a lot of laws because there has been a history. There has been a history of domination of the men and the women, not and oppression and so on and so forth. And the law has come to the rescue of the women to empower them with various. For example, in 2006, we did not have the Domestic Violence Act. It is so strange. Now, is it good? Is it bad? The point is, it existed, but there was no remedy available. Today, a domestic violence protection is given against the Domestic Violence Act. Domestic violence has been defined in physical, mental, financial violence. So they have expanded the scope of that also. Yes, in the same breath, I would say there has been misuse of it. There are certain sections of the women who have misused provisions like 498 IPC or domestic violence act or similar kind of situations which are there. Where courts have also come heavily on such cases. It's not that the courts are not. So you have this animation of judgment of the Supreme Court, which is really watered down what the rights of the police and the investigating authorities are on when a complaint under 498 Earlier, a woman would make a complaint, even her 80-year-old father-in-law, grandmother-in-law, some sister-in-law living in some part of the continent who were arrested with her. There was a cross of it. And I'm not saying in all cases, not few cases. But this was noticed by the court. And that is why animation clause judgment waters it down and makes it very, very, the section 41 notice has to be given. Statements have to be given. Efforts to be made by the police authorities to bring about settlement between them. And they register an FIR, but arrest will be under the exceptions. This is how law evolves. And law is abused, but law also evolves in both different. So somewhere as a society, we need to strike a balance between the two. And it's more like it's. We have a few questions from your side. All the call, but they were very anxious to. Okay, this one turn.
Students in Nagpur signing, you may please ask any questions.
Sabita, can you hear me? Sabita, please unmute yourself.
Yes, ma'am. Yes, ma'am.
Any questions from our students?
Yes, ma'am. That's what I'm asking. I'm checking.
Good afternoon, ma'am.
Yes, Veena. Yes, Veena.
Is my voice audible?
Yeah, of course. Please go ahead.
Yeah, I just want to ask a question. Is it correct that section 498A is now not applicable to relatives of husbands?
No, that's not true. It is still applicable the way it is there in the section 498. However, can you hear me, Veena?
Yes, ma'am.
Veena, can you hear me?
Yes, ma'am, I can hear you.
Okay, so 498 does not mean that it is not applicable to the relative. You can always make a complaint against in-laws or whatever the case may be. What the courts in the Animesh Kumar judgment has watered it down, that there could be proper investigation, there could be proper statements taken by the investigating officer with the husband in relative. What the courts are now doing, and this is more on a practical note rather than what is strictly in the law books, is that they are granting bail to the in-laws in case of FIRs, etc. lodged because of their age, because of their certain probability which may or may not be there. So the courts are a little liberal on that. But as far as the bail, as far as the husbands are concerned, the courts do need to get into all the detailing, understanding, sending it for mediation, bringing about settlement, and only in few cases they would, if not, they give strict bail conditions because they grant a bail to the husband. There are stringent bail conditions that he cannot sort of leave the country, or his passport is kept in the court's custody, and so on and so forth. But no, it doesn't mean the law, sorry, the section is the same, there's no change in that. Only the judgment has tried to exemplify the meaning of that particular law.
Okay, ma'am. Thank you, ma'am.
Anyone else? Students will Nadi Gusani. Any other questions? Ma'am, if it's okay, one more student had a question. Yeah, not okay.
Suppose a couple got married in 2019 and they didn't register their marriage and they had a child in 2020 and now they want to get their house. So what will be
They can get you.
and whose name the child will get? Because
One second answer. Let me just answer this, and that is why I was saying, what would we, the uniform civil code, to ensure that there is uniform? One thing would be compulsory registration of the marriages, failing which they would be declared. Today, the law of the land that registration of marriage is compulsory, but and mandatory, but not everybody is doing it. But that does not mean that the marriage is not taken. That does not mean ceremonies have not been undergone. They've not undergone ceremony. There's a child who's born from this relationship, which is marriage. A non-registration of a marriage does not make it mandatory as we see. Okay? You have to give proof of marriage unless one of the parties is contesting she's not my wife. Never got married. Then the wife will have to show photographs like the Mangal Sutra, we had Fera and whatever. These, eloped marriage. So the court recognizes that there is a marriage. The court recognizes there is a child born. And the courts will deal with it as if there is a marriage, as if there is a litigant whose marriage has been registered. Nothing takes it away. All the rights are the same, all the laws are the same.
So the burden of proof lies on the witnessing party.
So the burden of proof lies on, because of course the witnessing party are both the parties, but the one is acknowledging that there is marriage, and the other one saying that there is no marriage. When I say there is no marriage, then I just have to say that. Okay. Now how do, but if the other side proves it by saying these are the fairas we did, these are the ceremonies which we did, then the courts are going to get into the details of it, whether it is marriage performed, though not registered. These marriages are the, I was thinking when I was discussing that the Hindu non-Hindu marriages, most of these take place in this kind of marriage situation. And the authority, which is the registrar of marriages, without verifying whether both the parties are Hindu, get the marriage registered under the Hindu Marriage Act. So they are very happy. I mean, couple is happy. They are not supposed to be knowing they're going to a lawyer, and lawyers going to say, "Why don't you have this? This is what the law says." They are very happy. So it starts that these changes or these investigation. This questioning has to take place at the registration of the marriage itself. Then were you Hindu, who performed it, and all those questions, and an affidavit to be taken, that blah blah blah, etc. And then do some methodology. I'm just telling you what comes to my mind right now. But something will have to be done to state that they had got married. So when you go for a registration of normal marriage, they ask you for invite. You can say they ask you for a photo.
Then they ask me for other activities. And two witnesses. Now, how much can the authorities do beyond that? There's only so much I can.
I'm supposed to thank you right now, but I have a question. If it's okay for the host, because I mean, you opened the Pandora box of UCC questions, and as you said, it's important, it's mandatory for us to register our marriages. But in case we don't register our marriages, we know most marriages don't get registered, we'll be asked to prove photographs, etc. And when UCC also comes, don't you think, ma'am, the same pattern would be followed as far as even though registration again will be mandatory for every region conformity, but we can
See, once an enactment comes of this nature, and this again I'm telling you that this is how I foresee, and again there is no sort of set formula for that. They would have to put up these mechanisms at every places where the families are performed. First and foremost, in my view, they should shut down these so-called temples where these marriages take place. Because there is, I've seen so many cases where girls coming from well-to-do families, they fall in love with the driver, they fall in love with the waiter, and then he lures them, gets taken to some Bandra temple, Ganesh temple, and the priest is there who's wearing jeans and kids. And he does, I mean, I'm not on the correct, but he doesn't have that period. He doesn't, but he's wearing jeans and he's wearing kids and he doesn't remove his things. And he says, and then they go and then they issue some certificate. So and so they were start basing and then they give some certificate. Based on that, they go and get their marriage. And things like that. But the end of it is the marriage. So there should be stringent provisions taken by the authorities to shut down all these things. That there should be only specific places which are registered, licensed to conduct marriages. Okay, for simple people who don't want to spend money, but simple people. And then those registered it could be, just to give an example, it could be a boundary duty of that particular institute of that particular place, a temple, to get that the marriage is registered in their presence. And something like that has to come out, only then we may have a little more regularity.
I think we can all
I think it's very clear. Last second month, okay, second month. Okay.
Till now we have learned that nothing supersedes Constitution of India. But currently we are studying family law. I've seen some sections which are superseding Constitution of India, like guardianship in Muslim marriages, nikah halala, and polygamy. So I think it should be repealed and not subject even to judicial review. So what are your views?
See Article 25. Right of religion and religious practice.
But ma'am,
You also should understand that under this Hindu law, this being a parallel example. The court, not the court, the enactment has still retained the customary divorce. But this customary divorce, which is you don't have to go to a court, but like all the panchayats, whatever their particular thing is. But it could be questioned in a court of law. And there are certain parameters which have been given. It should be a long-standing custom, there should be examples of what it has been done, and in a way it should be fair and things like that. So even the enactment has retained the ethos of what a uncodified law was, or uncodified law was. Now today, you are absolutely right, and that is why we want a uniform civil code. Why do we want a uniform civil code? Because it is affecting my Muslim women sisters, because they are victims of all these things. They would be in a better position. Fortunately, those are Hindus, the courts and the law have been very, very kind to us, giving us all the rights. Girl born in a Hindu family has the right to go and marry, into all these things are there. But counterparts are facing this, and that's when they're not probably appreciated. I don't. I don't want to make any comment. Very sensitive.
okay, let it be the last one.
But I want to ask that as LGBTQ marriage is not really recognized, but still there are some people who are getting married. So what about the acceptation?
Today, I think that's a very interesting thing, and I think I'm very much for this. And I'm so happy the 377 has been struck down, because that was the most horrendous thing that I can tell you in my experience as a lawyer. I've seen so many cases where clients have come and opened out that I was forced to get married. My father, when my father knew I'm gay, I explained that I confessed to him I'm a gay partner. He said, no, you must get married and then you can get divorced and they can say, okay, you got married, you got divorced. But it cannot be there. So this kind of a mindset was there. There were cases where when women came to know about it that their husbands were gay, they would prosecute them, and the criminal thing was, I mean, the sanest of the. I remember a couple of matters where they were running from pillar to post only to hide. Why? Because it was disclosed that he was gay by sexual orientation. So I was extremely happy when this was struck down because they were really trapped in society which are very insensitive to them. But if you are going to they just achieve some baby step on decriminalizing. Now accepting them in the mainstream is what probably you and me as students of law want them to do. Why not? They're just like me. They're brighter than me, they're better than me. Because the sexual orientation is different. This is going to take some time in a society. So the gay marriage as we speak is not the law of the land. But if you see the latest judgment of Justice Chandrachud, I will tell you the name, but I'm not coming to me right now, wherein he has said what a family structure should be. And a family structure should also be consisting of family of the LGBTQ. So I get a kind of a judicial activist view from the court's point of view. But I'm sure that very soon, people like you will get into the mainstream and you will make it a thing that they should be given the equal rights of marriage and procreation. That's what I think.
Last. Is there someone from that side?
Students in Hari Goswami, do you have any other questions? Oh, I don't think there's any questions. Okay. Thank you so much, ma'am. Family law lecture will be far more interesting. We are going to continue our discussions now. Oh, I think we have a question.
Wait, just one last.
Please ask your question, unmute yourself and ask your question. Shruti?
Good afternoon, ma'am.
Yes, Kate.
Good afternoon, ma'am. My name is Kirti Kataria and I'm from NGLC College. I had one question. What court considers while determining the custody of a child?
So there are various factors which courts consider, but the guiding principle or the paramount principle is the best interest and welfare of the child. Now, what is the best interest and or welfare of the child? There are several factors: the background of the party, the age of the child, the sex of the child, the circumstances under which the child will be raised in a situation if it is given to A or if it is given to B. Psychological evaluation of the child to understand his preferences if he is of an intelligible age. So it keeps on changing as per the age of the child. Child below the age of 5 and 6, obviously there is no question of taking any preference or something. But a child 12 plus or 10 plus doesn't have a mind of his own. So these are the factors which are also considered. The background of the parents and which is what is more nourishing for the child's development and for his betterment. A mother may have no money, but she may give all the time and attention and all the values. Even then the mother will be given. So lack of money is not a consideration for not giving the custody. The father will be asked to give the child that. So they have to evaluate this in all the given set of circumstances.
Thank you so much, ma'am.
Pleasure.
Thank you so much, ma'am. I'm sure there will be many questions, and for this, I think I should take the liberty and invite you again, if possible. Please do come, ma'am. On behalf of the American School of Law, I extend a warm gratitude to everyone present here, especially to our esteemed guest, ma'am. Thank you so much for taking our time and addressing us all. It was definitely extremely enlightening. This event would have been possible without the support of our technical staff, Vegetarian University, and of course, our student volunteers. Thank you so much. I request everyone to please rise in the national.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Students, let's be outside and you may have a 2 minutes of interactive session with ma'am and ask any more questions if you have. Please don't walk out. Also, after this, we can have a nice photograph with ma'am. Please stay back.